Matter of got the abbreviations here, sorry. Prison Legal Services of New York versus DOCCS. Counsel?
Good afternoon, Your Honors, and may it please the Court. I'm Matthew McGowan for Appellant Prisoners Legal Services of New York. I'd like to reserve 4 minutes for rebuttal, please, Your Honor.
4, yes.
Thank you. The underlying questions in this case will typically evade review because respondent relied on inherently time-limited conditions to deny access to these records. And as a result, the agency's misinterpretation of important and threshold elements of the statute will generally be non-subject to litigation unless this court grants an exception to mootness.
Does the fact that you could that you could still look for attorney's fees, how does that impact whether or not it would be evading review? Because the court would still have to make a determination of the reasonableness of the court below withholding these records. So wouldn't that give you a review?
FOIL's fee-shifting provision, Your Honor, would not be adequate with regard to these specific questions because it applies a different standard than the actual standard for withholding records outright. The fee-shifting provision provides that there has to be no reasonable basis for the respondent's position in order to be entitled to fees. And a petitioner also has to have substantially prevailed, meaning they got all of the records at issue. So the courts below denied attorney's fees on both of those grounds. So here, only some of the records pertain to these important and novel questions. And also, the novelty and importance of the questions itself makes the attorney's fees provision inadequate to reach those, which is to say when there's a good faith dispute over what the statute means or how it should be applied, then agency may well have a basis that could be characterized as reasonable and yet still have acted unlawfully in withholding the records in the first place.
Is there a novelty, I assume you say there is a genuine novelty argument to be made with respect to the ongoing investigation exception that was invoked. Can you just sort of elaborate on what's novel there?
What's novel there, Your Honor, is that more than 45 years after FOIL has been enacted, there's never been any substantive attention from any appellate court, and particularly this court, on what the term compiled for means. That's a question that the U.S. Supreme Court has addressed in John Doe agency with respect to federal FOIA, but it remains unaddressed at the New York State level with respect to our statute. So there is a genuine and novel question as to what it actually means for a record to be compiled for a law enforcement purpose. And while FOIA may be instructive in the New York State interpretation of FOIL, the Court of Appeals is by no means bound by the federal interpretation. And appellant respectfully submits that Justice Scalia's dissent in John Doe agency is a preferred meaning.
And is it your position that this will consistently evade review? I mean, if it's being used for law enforcement purposes, at some point the FOIL hearing is going to happen, and if there's still an ongoing investigation, that is going to be asserted. So I'm not sure I fully comprehend how this evades review.
As this court recognized in Lesher v. Hines, investigations, once they conclude, generally will terminate the application of that exemption. And as the court also recognized in Lesher, investigations generally conclude in a reasonable amount of time.
But counsel, those were cases where we are applying the mootness exception, determining if we're going to apply it. This case comes to us in a very different posture. Really, the issue seems to me here is, did the appellate division abuse its discretion in refusing to apply the mootness exception? And to me, that's a very different analysis. Maybe we would apply it differently, but why as a matter of law would we say the appellate division in these circumstances abused its discretion in refusing to apply it?
I think in part it's that the capability of a question evading review is not something that has to be uniform, which is to say, as this court recognized in City of New York v. Mall, the mere possibility of evading in the context of foster care placements was enough. And
that might be a very good reason for us to decide we wanted to apply a mootness exception, but is it a reason for us to say the appellate division abused its discretion in refusing to do that?
the reason why appellant would answer that affirmatively is because of the importance and novelty of the underlying question, which is to say the exception to mootness involves three elements. When viewed in total, if there's any ambiguity in terms of how likely something is to evade review or whether the appellate division abused its discretion in determining that something may not consistently evade review, the underlying novelty could resolve that in favor of this court reaching the question.
We have two cases, Matter of Anonymous and I think David C., where we've done this. And I think those involved provisions of the mental health law where the triggering events underneath it were 14 days, and the argument was these are going to consistently evade review, and we said it wasn't an abuse of discretion for the appellate division to apply mootness, not refuse to apply the mootness exception. So why, again, would we say as a matter of law they abuse their discretion here?
Well, there's two elements to this case, Your Honor. One dealing with the interagency materials exemption and one dealing with the law enforcement exemption. It may be a more challenging question to reach to conclude that the appellate division abused its discretion with respect to law enforcement investigations, because there is generally a longer timeline for an investigation or a criminal prosecution. But with respect to the interagency materials question here in particular, the appellate division, in our opinion, did not give adequate stock to the timeline on which the supposed finalization process of prison unusual incidents.
On that, I take it you're talking about the UI report, yes?
That's right, Your Honor.
Okay, so you assert, I think, in your brief that the preliminary UI reports are routinely denied, but I don't see any support for that in the record. Is there a place in the record that establishes that?
The record establishes it insofar as that's what the agency did in this instance.
In this instance, right, but one question, I think, that we generally look at in deciding whether the mootness exception applies and would need to look at in gauging whether the appellate division abused its discretion is whether or not it routinely evades review. So what I'm asking is there anything in the record which goes to the question of whether the practice of denying a preliminary report and then providing a final report is commonplace?
There's several things that can support that inference for this court, which is that both courts below did not contest the likelihood of recurrence.
But nothing specific in the record that affirmatively lays that out, I take it?
Nothing that identifies a specific policy other than the fact that respondent has not meaningfully contested that practice in its briefs.
Am I wrong in reading the record that there's two parts to this, right? Auburn Clinton?
Correct.
You have not appealed the Clinton part here. We're not arguing about the Clinton materials. But in that case, which is part of this one, they did turn over redacted reports to you, as I read the record.
It's our understanding, Your Honor, that those were produced because those reports had allegedly been finalized. The reason why there is a partially redacted report in the record, which in and of itself allows this court to reach the substantive questions by seeing what actually is happening.
But my point just being, it's not that they routinely deny access to the reports on this record. It seems that they produced at least redacted reports right away in the case you're not appealing, in Clinton.
So several months had passed from the time of the incident to the time of the actual production of those records, and the agency had ostensibly finalized the report in that context. So what's really at issue is the delay that's wrought by this
Well, you requested that on July 23rd, and they responded August 6th.
for an underlying incident in May. So there was a several-month delay in which the agency allegedly had finalized the report, and that delay has real-world consequences in the sense that the public has a right of timely access under FOIL.
Are you still seeking the preliminary report?
So as we understand it, Your Honor, preliminary is simply a status that the agency assigns. It's not actually a different document. The narrative, objective, factual content in that report should, in most instances or all instances, be one and the same. So there's a relatively opaque finalization process, but the core of this issue is that those narrative reports reflect written memorializations of events that happened by staff who were present and saw them. So it's a chilling prospect that there needs to be any secret deliberative process for government actors to decide what happened.
So I thought you were going to explain why in the record there's a preliminary report.
Our understanding, Your Honor, is that that is a redacted final report.
So are you saying there's no practical difference between the underlying report and the final report?
So the specific internal mechanics are relatively opaque to appellant, but what's clear is that the actual narrative content, which comprises the vast majority of the report itself, there's a description of an incident, there's names, there are dates, there are
So are
parties
you
involved.
saying you are in agreement that the preliminary report becomes a final report and they are effectively the same thing?
Our understanding is that the narrative content is the same thing for all practical purposes.
Okay.
And it's that reason why it's improper to deny that in the first instance, which is this court recognized in no uncertain terms in Gould that objective factual information is not.
Did you ask for all the reports or the report?
The FOIL request, Your Honor, asked for all UI reports. But our understanding is that it's effectively a single document that the agency assigns a so-called status of being preliminary. But for all intents and purposes, those narrative sections are static facts that cannot be changed, such that whether it's deemed preliminary or final doesn't have a true bearing on whether it's...
So if the agency didn't distinguish with respect to any labeling between preliminary or final and provided it to you at some point when it internally viewed it as finalized, would you have an argument, and what would it be?
I'm sorry, Your Honor, if...
In other words, I take it you're saying that you're not actually seeking a distinct document. You're seeking the same document earlier in time. Is that fair to say? You're not suggesting that there is a material difference between the content of the preliminary report and the final report?
That's consistent with appellant's understanding of how the process works.
Okay,
Your Honor, yes.
and so if the agency didn't dub one preliminary and the other final, would your objection fall away? I'm just trying to understand how much of it is just about the timing as opposed to a discrete document that you want to get access to and can't.
The timing, in effect, is everything. It's that it's unlawful at the outset for the agency to deny access to factual material.
In this case, did you receive the document when you eventually received it too late to put it to whatever use you had intended to use it? And if not, how does that impact on your substantiality argument?
It, in fact, was received too late in that there are very short administrative appeal timelines. Appellant's primary practice areas include, I notice that my light is on, may I finish? Or?
Please continue. Yep.
Appellant's main practice areas include challenging administrative prison disciplinary hearings, which have tight appeal deadlines. There's no independent discovery mechanism. So the only means of getting these documents is using the Freedom of Information law. By getting that document after the appeal window had closed, respondent was deprived of, appellant rather, was deprived of reviewing it for purposes of the appeal.
I'm sorry if I can ask. So I'm a little unclear about your prior response to Judge Halligan. So if they have something that they've designated a preliminary UI report, and then they do either change something or add something or delete something, take it whichever way you wish, and that is what they label the final report. That's why I asked about what you requested. I thought your request was, I want to see both. Some redactions applied, of course, they can seek to redact and you can challenge it and move forward. But I thought you were requesting both.
To the extent the request asked for all UIs, Your Honor, it simply meant had there been multiple incidents or if the agency had characterized it in multiple incidents and therefore generated multiple reports, both of which could have been tracked on this preliminary finalization timeline. It wasn't asking specifically for the document that's internally designated as preliminary.
So if they had a preliminary, something they designated a preliminary report and then they finalized it and made it final, you would be satisfied with just what was designated final. You would then say, I don't need to see whatever was originally designated as a preliminary report, even if those things had changed.
As a general matter, that's correct, Your Honor. We simply
How would
want
you know
timely...
they changed?
I'm sorry?
How would you know they'd changed?
Well, to some extent, we don't have any insight into their actual record-keeping practices, whether there is a document retained that is a so-called preliminary version. So that may be something that could warrant from further factual development. But as a baseline matter, the objective factual information is always outside the scope of the interagency exemption at the time it's written because it's factual, objective content at that first writing.
That's what I'm saying. I'll ask him, but let's assume for purposes of this hypothetical, if between whatever they've labeled a designated preliminary report and what they then label as finalized, there is some change in the factual rendition. If you only get the final, how would you know?
That's certainly an interesting question, Your Honor, and it would raise very real and grave concerns about the agency's practice in changing their narrative account. And to the extent that there are documents that remain on file that could reflect those, appellant would be interested in reviewing both documents.
I may have misunderstood something because your last answer just was the opposite of what I thought you would have said. I understood you say you want the reports as quickly as you can get them because you have a pressing time need for them, and that the preliminary report and the final report, 99% of the time at least, you believe are the same. So I would have thought you would have said what I really want is the preliminary report because I'll get it sooner, but you said, no, I want the final report, and now I'm confused.
Essentially, it's immaterial, Your Honor, to appellant what the agency calls it. We want the objective narrative
Yeah,
content.
but the question is, when do you want it? So if we know that they have one they call preliminary and later they have one we call final, don't you want the earlier one, whatever it's called?
We certainly would like the information as soon as possible, regardless of what the agency calls it. That's correct, Your Honor. But there are a number of instances in which appellant seeks records. So in reviewing a use of force, for example, if the agency has changed its story, then appellant would be interested in reviewing how that has changed. So the public has a wide variety of reasons why they may want access to records. There are many conceivable instances in which noting and being able to confirm that the government has changed its position as to the basic facts would be important. In the context of an administrative disciplinary hearing, for example, time is absolutely of the essence.
Thank you.
Thank you.
May it please the Court, Beasley Kiernan for DOCCS. The Appellate Division did not abuse its discretion in declining to apply the mootness exception here because the issues petitioner raises on appeal do not typically evade review. Take the intra-agency exemption. If a FOIL requester seeks a draft document, that request does not become moot merely because the agency provides a final version of the document. In this particular
What
case,
would change in a UI from preliminary draft, whatever the agency is designating it, and the final, or again, whatever you designated? What would change?
that goes to the nature of a UI report. It's not a witness statement. It's not a report by a DOCCS employee who witnessed an unusual event. A UI report reflects DOCCS's considered judgment about what happened during a significant incident at a DOCCS facility. It's prepared by a watch commander who gathers statements, interviews witnesses, reviews video footage, photographs, and writes a narrative of the results of his investigation. And then the preliminary report goes to DOCCS central office, which checks for any inconsistencies, makes sure the investigation was comprehensive. And then it goes to the facility superintendent who signs it. He reviews the report, and if there's a use of force, he makes a determination about whether that use of force was necessary.
And what if they
appropriate.
find inconsistencies at that second, well, in the middle?
And that may be what happened here. The Auburn incident was a large-scale violent
No,
altercation.
what happens? No, I'm
Well,
just
there's more-
generically, what would happen?
There'd be more investigation, more.
What happens to that version of a report that was prepared, that you're saying at a second level is determined to be inconsistent? I'm not sure inconsistent with what, but let's just go with that. What happens to that first report?
What happens to I'm not sure whether DOCCS maintains a copy of the earlier report. These aren't necessarily static versions. This is information entered into, I believe, a computer terminal. So I'm not sure if the preliminary version still exists. If it was printed out at any point, then the printouts would still exist.
But I take it your point is, once the levels of review are complete, that is then I'll call it, for lack of a better term, the official report.
That's the official report. That's
Okay.
correct,
And,
Your Honor.
and if there were distinct versions saved, and there had been a request for both the preliminary report and the final report, would you agree that if the agency said, we'll turn over the final report, but we're going to invoke the exemption as to the preliminary report, that request would not be moot should appellant wish to continue to pursue it?
That's correct. That's correct. In this particular case, PLS accepted the production of the final report as fulfillment of its FOIL request. That's what PLS said in its reply in Supreme Court at 404 of the record. But in a different case, if a requester actually sought a draft, that would not become moot.
And can you tell us, I realize it may not be in the record, but perhaps you know from your client, how long does it generally take? I'm sure it's different, depending on the complexity of the incident, but how long does it generally take for a report to become finalized?
Under Directive 4004, which is not in the record, the superintendent is supposed to sign the final version within 10 days of the incident. So it's supposed to occur very quickly.
And so the window in which one would not be able to get a report because it has not yet been finalized should be, if that directive is being complied with, I take it relatively short.
That's correct, Your Honor. And to be fair, disciplinary proceedings are also conducted very quickly if an individual is placed in segregated confinement. I believe the hearing has to take place within 5 days afterwards.
What about the appeal time on the hearing?
The appeal timeline is somewhat longer. So if the final report is finalized by 10 days after the incident, it should be available for review within the time frame to appeal and to decide that administrative appeal. I'll also note that there's been a rule change since the events at issue in this case occurred. Under 7 NYCRR 251-5.2, an incarcerated individual may be represented at a disciplinary hearing. So if PLS gets involved at the disciplinary hearing stage, my understanding is that the representative will have the same access to documents that the incarcerated individual has, further allaying any potential concerns PLS has.
You mean through some sort of discovery process in the administrative hearing, or through FOIL?
Not through FOIL, just by being present at the hearing.
So they would have the same access as the prisoner would have?
That's my understanding.
Do they have it in advance or at the hearing? Because I thought you just said at the hearing, just to clarify.
I'm not sure. These UI reports are typically only introduced at the request of the incarcerated individual. I'm not sure if the individual gets notice ahead of the hearing or receives the documents at the hearing.
But other, whatever else might be submitted at the hearing, do they get to see it in advance or just at the hearing?
I will let I'm not sure. I'm not
Okay,
sure. I
that's fair.
believe there's some notice, but I'm not sure.
Thank you.
And with respect to one who is unrepresented, would they still continue to have no access?
I believe in that case, if PLS stepped in later on, then DOCCS would ask PLS to FOIL it.
But if they weren't represented, if they
Right.
if they were self-represented,
Right.
would they have access to these contested documents?
I think DOCCS would direct PLS to make a FOIL request, so it's not the same access. They wouldn't receive it at the hearing. They wouldn't be present at the hearing. But as the record reflects in this case, DOCCS does expeditiously respond to FOIL requests in as little as a week or two, giving PLS an opportunity to review documents when it would be helpful for them to do so. It's just that in this case, the unusual incident report was not finalized. It was still subject to review. The state was still checking it for accuracy. It would have been premature to disclose it at that stage, and it would have undermined the purpose of the intra-agency exemption, which is to allow individuals within an agency to exchange their views freely as part of the deliberative process without the
Well,
concern.
what can you point to that says that this UI was just that, engaging in a deliberative process? I think you mentioned before that it was just somebody's observation, a collection of witness statements. So I'm a little confused about where you see it was deliberative.
It's not just a collection of witness statements, and I encourage your honors to look at the unusual incident report in the record, beginning at page 328, related to the Clinton incident. There's a narrative, but that reflects DOCCS's official view of what happened. It's not just a collation of every single witness's
But
statement.
how do you distinguish that from Gold?
In Gold, the petitioner requested police reports, and
Right, but how are those reports different from a UI report?
this court explained that the police report contained a lot of objective information recorded by the police officer. There was
So too does the redacted report, I would say, in the record.
well, in Gold 2, you're talking about a finalized police report. There's no draft form of that. The UI report is developed by facility staff, not necessarily someone who witnessed the incident, who is gathering information and coming up with DOCCS.
I realize there's obviously a threshold mootness question, but just on the merits of the disclosure question, is it permissible to redact any portions that you think might reflect deliberative process, or is the entire document something that has to be evaluated all in or all out?
Well, it's a fact-specific determination. Every time the agency,
But I just mean as a matter of law, is there anything that would prevent the agency from, if there are specific responses that, in the agency's view, do reveal deliberative process as opposed to facts, from redacting those and then turning over the document?
In DOCCS's view, the facts relayed in the unusual incident report are still subject to change. Until the report is finalized, the state is still checking it for accuracy.
But how are the, how though, yeah, but that to me is about the preliminary versus final. I'm asking about the deliberative process point. How would the factual components of a UI report be different from the facts gathered in the police report in gold?
Again, Your Honor, it's a work in progress. It's not necessarily a static document. It's a watch commander who is gathering information and adding information to the narrative. And until it's in final form, it would be premature to disclose it. Because when the state discloses information, objective information under FOIL, it carries the imprimatur of the state. And if you're talking about a preliminary...
That's true with, I would think, a police report as well, no? It carries the imprimatur of the city law enforcement agency.
It captures what that particular police officer did in that particular investigation. I understand there are similarities, but this case, I think, is distinguishable because of the nature of a UI report. It reflects the agency's considered view about what happened. It involves collecting statements from multiple agency employees, whereas police reports, it's principally one police officer writing down what he or she has done in an investigation.
The way you
checklist.
describe that, it sounds almost as if your argument is that the narrative portion of the UI at issue here is something more like an analysis with a fact-finding involved. Like, you collect the reports, you synthesize them, and then you make some sort of statement about what really happened. Is it that, or is it, to use your adversary's words, objective, factual / narrative descriptions of events?
It does reflect the agency's deliberative review of information and the agency's final determination about what occurred during an unusual incident. It's not witness statements. Those are disclosable. DOCCS is not a
So,
agency
that being the case, I understood your adversary to argue that and I'll use his words again, objective, factual / deliberative portions, you wouldn't expect them to change from the preliminary report to the end. And I understood that argument because when facts are facts, they don't change from preliminary to final. But now, I think you're arguing that it's not really that factual, it's more a series of conclusions or determinations. Is that what you're saying the UI is?
It is more akin to factual findings, Your Honor, yes, because it's prepared by someone who didn't necessarily witness the incident.
So that would suggest to me that they could very easily change between preliminary and final result.
They do, and I understand that it really is a work in progress. It does change. They tend to be finalized very quickly, within 10 days, so usually there's not much factual development after the narrative is initially written. But in cases where there may be inconsistencies or there may be a need for further investigation, those factual findings genuinely can change.
Let me just, if I can drill on this a little bit. When you say inconsistencies, and you say part of what the UI is doing is presenting a report, if I can call it that, on this investigation, at least at that first stage, which may include speaking to witnesses and getting their statement. So is it that then the individuals filling out the UI at the first stage is making an assessment about the witness statements, or literally just again recording what the witnesses' statements are, and someone else, let's say one witness says it happened this way, another witness says it happened that way? What happens in the UI report? Are you saying that DOCCS decides, we believe it happened the way the first person said it happened, and we, as a judgment call, because I thought you said they're making judgment calls,
Right.
adopt that version?
It's a narrative about what happens. It doesn't recount what each witness says, and again, I encourage your honors to look at the Blanchard UI report. between pages 328 and
Okay,
345 of the record.
just try answering that question. If two witnesses give different statements about what they claim to have observed that are in conflict, are you saying that during this process, then someone up the chain decides, I'm crediting A's version over B's version, and that's what will become our formal articulation of what occurred?
Yes, DOCCS is
Okay.
making a credibility.
So then would they have access to B's version at any time, anywhere?
If B's version is in a witness statement,
If it is not?
if it is not, it wouldn't be subject to FOIL
So,
disclosure.
and if B's statement is only in the preliminary, what we're calling the preliminary report, you would not turn that over because you're only going to turn over the final, which is going to include A's statement as what DOCCS believes is what occurred. Am I getting that right?
No, based on the UI reports that I've seen, including the one in the record, the agency is not saying witness B says this. That's just not in the UI report. Instead, it's a narrative account of the
Yes, but
incident.
again, the narrative, as I understood you, the narrative is based, because you said the person who's going to make that decision was not present. It's going to be based on what others may have said, perhaps some other material that's been collected to help make clear the way the events evolved. So my question is, again, if it's in that UI that's preliminary but is not reflected in the final, unless, as you say, it's in a witness statement that they could request and get, they will not otherwise know. Is that correct? They will not otherwise know that DOCCS decided to choose version A over version B.
In the context of FOIL, that information, if there is objective information that
Yes.
only exists in a draft document,
Yes.
then a trial court could certainly say, you have to disclose this information. And then
But
that
you
would be
would, what I'm saying is that you would not turn it over. I understand that they can challenge that, but your DOCCS
Right.
position is, we're not turning that over.
Because of the nature of the UI report, that is correct. If I may just briefly, of course, if there's litigation about this later on, and a plaintiff requests this kind of information in discovery, and it's still available, that's a different standard, of course.
But you're
But
saying you don't know if they preserve it.
if it's printed out, then it's likely preserved. I'm not sure if it's otherwise preserved.
Thank you.
Unless there are
Thank
any
you.
further questions, I urge the court to affirm the decision below.
Thank you.
Thank you.
Just briefly, Your Honors, a clarification on the timeline. It would be virtually unheard of in appellant's practice to receive a finalized report within 10 days. There's a statutory mandate to acknowledge receipt of a FOIL request in 5 business days, but it is the routine practice for that finalization process to take far longer. And the record shows that in this instance, with respect to the contested Bradley report, it took more than 4 months, which is to say the incident took place in May of 2019. You can see that on page 149 of the record. On page 172 of the record, a FOIL appeal was denied because the report was still allegedly non-final on September 18th of 2019.
So why can't you get review of the issues you want reviewed by demanding the preliminary reports or drafts or whatever you want to call them, have them refused, and then you get review?
That would be one potential strategy, Your Honor, but appellant's understanding is that it's effectively the same document with simply a different status
Well,
applied.
it's okay, but if they're going to refuse to give you something, are they going to, then you have a refusal, and you could litigate that.
That would be a conceivable avenue for litigation. There's the underlying factual issue, which is not developed on this record, as to whether there's actually a preliminary version retained at all. So it may well be the response is simply this document doesn't exist, at which case this issue continues to remain unreviewed into the unforeseeable future.
But if they're saying it's not final, how do they not have a preliminary?
So final doesn't necessarily indicate 2 retained copies of a document. It simply could be a status that suggests they're still reviewing it. So there's not necessarily a final that's retained on file or along with a preliminary that continues to exist. So
It's kind of a tough question, right? So if it takes me 5 days to write a document, right, I would think it would be difficult to succeed on a request that says, I want as far as you've gotten on day 1, and then I want as far as you've gotten on day 2, et cetera, right? So it seems like the strength of the request does turn in part on the actual practice and whether or not there is a distinct item called a preliminary report versus a final report.
That's true, Your Honor, and there may well be room for further factual development on remand, but there's a essential underlying question this court could still reach on this record, which is that, as the Appellate Division 3rd Department recognized in 2019 in matter of PLS v. DOCCS, UI reports at their core are written memorializations of events that happened. So they cannot be properly characterized as deliberative within the traditional meaning of the intra-agency materials exemption. There may be some potential inaccuracies, but as this court recognized in no uncertain terms in Gold, a witness statement is still factual information subject to disclosure under that
So my
exemption.
hypothetical is pure fantasy?
I'm
It's
sorry,
not
Your Honor?
possible, so my hypothetical to him is pure fantasy? It's not possible that one witness says it happens this way, one witness says it happens that way, and DOCCS decides we're going to accept the witness A version and not witness B, and then never includes witness B's articulation in the final report, because as counsel made clear, it's DOCCS' narrative.
It could well be that the agency makes that determination, but the underlying statements themselves would remain factual content. And what would properly be deliberative is if there's
Yes, but
some...
if there was no statement, I thought I asked that, maybe I didn't, I asked that. He said, if there was a statement, yes. But if there is no such written statement by the witness, it's just an interview that's then written up by someone else. Or, again, is that fantasy? Does that not happen?
Again, there's an opaque nature in terms of appellant's ability to know the actual internal processes, but my understanding is that it would never be done simply verbally. There would be some exchange of written reports, and again, as the witness statements were recognized to be in Gould, those, even though they may contain inaccuracies because of inherent fallibility of human observation, those accounts still are the kinds of factual information that are
Counsel,
disclosed.
it seems like we've kind of, I'm sorry, may I just?
Yeah, of course.
Thank you. It seems like we've gone off on this road. You asked for the unusual incident report. We agree they produced what you asked for, because getting to Judge Halligan's question, yes, you could ask for a report, and like, give me the report right now, and they could give it to you, and it's not finished, then you would still want the later report, right? You wouldn't only want each snapshot. You're going to want their final conclusion, right? Which is what you essentially asked for here and what you got. So to me, the straightforward question here is, you asked for something, you got it, it mooted this litigation, and the question is, was the mootness exception properly declined by the appellate division? Whether and what's in other reports or on a computer system, it seems like this was mooted out by the time of the response by the prisoner officials, and, you know, at least in the court. And now, what you would like is someone to review this even though it's moot.
That's correct, Your Honor, because there was real-world harm wrought from the delay, and it was unlawful to deny that at the outset, and that's the issue that we would like the court to reach.
Understood.
Thank you, Your Honors.
Thank you.